You were watching the news. Or maybe it was a family dinner, or maybe it was just two people arguing on the internet. And somebody said it. That's unconstitutional. And everyone nodded. And you nodded too. But somewhere in the back of your mind, a quiet voice asked a question you didn't say out loud. What does that actually mean? You've heard the word constitutional your entire life. You've heard people talk about rights, amendments, the Supreme Court, separation of powers. You've seen politicians wave copies of the Constitution on camera. You've heard people say, "I know my rights," with total confidence. And every time, you felt like you were supposed to understand what they meant. But you didn't. Not really. Not in a way you could explain to someone else without freezing halfway through the sentence. That is not your fault. Nobody ever sat you down and explained what constitutional law actually is. Not as a list of amendments to memorize, not as a history lecture about the founding fathers, but as a machine, a working system with moving parts that you can see and understand. That stops today. By the end of this video, you will understand constitutional law. You will know what the Constitution actually does, why it exists, and how it works. You will be able to hear someone say, "That's unconstitutional," and know instantly whether they're right or wrong. No jargon, no textbook, just the real idea explained from the ground up. Here's the truth that explains all of constitutional law. Everything in this subject comes from two questions. First, what can the government do? Second, what can't it do? Those two questions have names. The first is called powers, the second is called rights. Every single rule, every amendment, every Supreme Court case, every political argument about the Constitution is really just one of those two questions wearing different clothes. By the end of this video, you will understand both, and you will see how they are really the same question, asked from opposite sides. We are going to start with the foundation that makes the rest possible. But first, you need to see the world that made the Constitution necessary in the first place. Imagine you live in a country where one person makes all the rules. He decides the taxes. He decides who goes to jail. He decides what you are allowed to say. And if you disagree with any of it, he decides what happens to you. There is no appeal. There is no second opinion. There is no document you can point to and say, "You are not allowed to do that." Because there is no such document. He is the government. The government is him. And whatever he says goes. Now imagine this going on for decades, centuries. Imagine generations of people being taxed without being asked, imprisoned without being tried, silenced without explanation. You can see the problem. Not just that it is cruel, but that it is unstable. A government with no limits will always, eventually, abuse its power. Not because the people running it are always evil, but because power without boundaries has no reason to stop. It grows until something breaks. That is the world the Constitution was designed to prevent. The people who wrote it had just lived through exactly that kind of government. The British Crown taxed them without representation, quartered soldiers in their homes, held trials without juries, punished speech, seized property, and when the colonists finally broke free, they did not just want a new government. They wanted a new kind of government, one that came with a rule book it could not rewrite, one that had limits built into its own skeleton. Think about that. Imagine a board game where one player can change the rules in the middle of the game. Nobody would play. The game only works if the rules are fixed and everyone, including the strongest player, has to follow them. The Constitution is that rulebook, and the strongest player is the government itself. Before you can understand powers or rights, you need to understand the one idea that makes both of them possible. That idea is called limited government. Here is what limited government means. The government of the United States does not have unlimited power. It is not a king. It is not a parent. It is not a god. It is a creature of the Constitution. It was created by that document, and it can only do what that document allows. Anything the Constitution does not authorize, the government cannot do. Not should not. Cannot. The power simply does not exist. This sounds like a simple concept, but it is the single most important idea in all of constitutional law. Every rule we are about to look at, every argument about what the government can or cannot do, is built on this foundation. If you understand limited government, everything else clicks into place. If you don't, nothing else makes sense. Think about it this way. The government is like an employee hired with a very specific job description. The Constitution is that job description. It says, you can collect taxes, you can raise an army, you can regulate trade between states, you can do these specific things and these specific things only. Anything not listed in the job description is not part of the job. And just like an employee who starts doing things outside their job description will get called into the boss's office, a government that acts outside the Constitution will get called into a courtroom. That is the foundation. The government is not inherently powerful. It is only as powerful as the Constitution allows it to be. Now that you have that, the two tools are easy. The first tool is powers. Powers answer the first question, what can the government do? The Constitution does not just say, the government exists. It says exactly what the government is allowed to do, and exactly how it is structured to do it. And the way it structures that power is one of the most clever designs in political history. Start with the most fundamental division. The Constitution splits the federal government into three separate branches. The legislature, which is Congress, makes the laws. The executive, which is the president, enforces the laws. The judiciary, which is the courts, interprets the laws. Three different jobs. Three different groups of people, none of them allowed to do the other's job. This is called separation of powers, and it exists for one reason: to make sure no single person or group can accumulate enough power to become the thing the founders just fought a war to escape. Picture three locks on the same door. No single key opens it. You need all three. That is not an accident. That is the whole point. The system was designed to be slow, to be frustrating, to require cooperation, because the alternative, a system where one branch can act alone, is the system they had just overthrown. But separation is not enough by itself. What if one branch just ignores the others? What if the president decides to make laws on his own? What if Congress refuses to be checked? That is where checks and balances come in. Each branch has specific tools to limit the other two. Congress can pass a law. The president can veto it. Congress can override the veto with enough votes. The Supreme Court can strike down the law entirely if it violates the Constitution. The president appoints judges. The Senate confirms them. Every power has a counterpower. Every move has a response. It is like a three-way tug of war where nobody ever fully wins, and that is exactly how it is supposed to work. Now look at the other side of the power structure. The Constitution does not just divide power between three branches. It also divides power between two levels, the federal government and the state governments. This is called federalism. The federal government handles things that affect the whole country, like national defense, immigration, and interstate trade. State governments handle things that are more local, like education, policing, and family law. Some areas overlap, and when they do, federal law wins. But the key insight is this: the federal government does not have general authority over your daily life. Most of the laws that affect you on a Tuesday morning, traffic laws, school rules, property taxes, come from your state, not from Washington. The last piece of powers is the distinction between what is written and what is implied. The Constitution lists specific powers called enumerated powers. Congress can tax. Congress can declare war. Congress can regulate interstate commerce. Those are spelled out. But the Constitution also includes a clause that says Congress can make any law necessary and proper for carrying out those listed powers. This implied powers clause is where most of the modern arguments happen. Does the power to regulate interstate commerce include the power to regulate the internet? Does it include healthcare? These are not easy questions, and they are the reason constitutional law stays alive and contested centuries after the document was written. The key point of powers is this: the Constitution gives the government a specific toolkit. 3 branches, 2 levels, enumerated and implied authorities. Everything the government does must trace back to something in that toolkit. If it cannot, the action is unconstitutional. That is the first side of the line. But knowing what the government can do is only half the picture. What about the things it can never do, no matter what? That is the second tool. The second tool is rights. Rights answer the second question: what can the government not do? If powers are the engine of the government, rights are the walls it cannot drive through. They are lines painted on the ground. The government can walk up to the line. It can lean over it, but it cannot cross it. And if it does, the judiciary is supposed to push it back. The most famous collection of these lines is the Bill of Rights, the first 10 amendments to the Constitution. And here is something most people do not realize. Every single one of those amendments is a reaction to a specific abuse. They are not abstract philosophical ideals pulled from thin air. They are scars. The First Amendment protects speech, religion, and the press, because the British government had censored all 3. The Third Amendment says the government cannot force you to house soldiers, because the British Crown had done exactly that. The Fourth Amendment protects against unreasonable searches, because British officers used to break down doors with general warrants that did not name a specific person or crime. The Fifth Amendment guarantees due process because people had been imprisoned without trial. Read the Bill of Rights, and you are reading a complaint letter to the King of England translated into law. But rights go beyond the Bill of Rights. 2 concepts buried in the 14th Amendment changed everything. The first is due process. Due process means the government cannot take away your life, your liberty, or your property without following fair procedures. It cannot just seize your house. It has to give you notice, a hearing, a chance to respond. The process matters as much as the outcome. Think about it like this. Even if the government is right that you owe taxes, it still has to prove it through proper steps. Skipping the steps makes the action unconstitutional, even if the conclusion was correct. The second concept is equal protection. Equal protection means the government cannot treat people differently based on certain characteristics without a very strong reason. It cannot create one set of rules for one group and a different set for another unless it can justify the distinction. This is the constitutional basis for civil rights law, anti-discrimination rulings, and some of the most important Supreme Court decisions in history. The principle is deceptively simple. The law must apply equally. In practice, figuring out what equally means has kept courts busy for over a century. Now here is a detail that surprises most people. The Bill of Rights was originally written to limit only the federal government, not the states. For most of American history, your state government could, in theory, restrict your speech or deny you a jury trial without violating the Constitution. That changed through a process called incorporation. Over decades, the Supreme Court ruled, case by case, that most of the protections in the Bill of Rights also apply to state governments through the 14th Amendment. This was not automatic. It happened one right at a time through individual court decisions. And it means that the rights you take for granted today as protections against any government action only became universal relatively recently in American history. The key point of rights is this: rights are not gifts the government gives you. They are fences the government cannot cross. They exist whether the government acknowledges them or not. The Constitution does not create your rights. It forbids the government from violating them. That distinction matters more than almost anything else in constitutional law. Here is the part most people never see. Powers and rights look like two separate systems. One tells the government what it can do. The other tells it what it cannot do. Two lists, two analyses, two chapters in every textbook. But look closer. What is a power? It is something the government is authorized to do. What is a right? It is something the government is not authorized to do. They are not two lists. They are one line, one single boundary. On one side, government authority. On the other side, individual liberty. Every power the government has is, by definition, a space where your rights do not block it. Every right you have is, by definition, a power the government does not possess. They are the same frontier, seen from opposite directions. Imagine you are standing on a border. You look north, and you see everything the government can do. You look south, and you see everything it cannot touch. You did not move. The border did not move. You just turned around. That is constitutional law. One line, two directions. The entire subject is an argument about where that line sits. This is why every major constitutional battle, from free speech cases to gun rights to healthcare mandates, is really the same fight. Someone is saying the line should be here, and someone else is saying it should be there. Powers versus rights is not two debates. It is one debate that never ends, because the line has to be redrawn for every new situation the founders never imagined. Once you see constitutional law this way, you cannot unsee it. Here is what most people get wrong. The first mistake is thinking the Constitution gives you your rights. It does not. Your rights exist independently. The Constitution restrains the government from interfering with them. The difference matters. If the Constitution gave you rights, it could take them away. But if rights exist outside the document, the Constitution is just a shield, not the source. The second mistake is thinking the three branches are equal in the way three identical boxes are equal. They are not. They are deliberately unequal. Congress was designed to be the most powerful branch because it is closest to the people. The president was given strong but limited authority. The judiciary was given lifetime tenure specifically so judges would not have to worry about popularity. The imbalance is intentional. It creates friction, and friction prevents tyranny. The third mistake is confusing unconstitutional with illegal. They are different things. A law can be perfectly legal, passed by Congress, signed by the president, enforced by the police, and still be unconstitutional if it crosses the line into protected rights. And something can be illegal, like jaywalking, without raising any constitutional question at all. Unconstitutional means the government exceeded its authority. Illegal means someone broke a rule. The two overlap sometimes, but they are not the same concept. The fourth mistake is thinking the Constitution is frozen in time. It was specifically designed to be amended. There is a process, deliberately difficult, for changing it. 27 amendments have been added so far. The founders knew the world would change. They built an update mechanism into the system. The Constitution is stable, not static. It bends slowly, but it bends. Let me show you exactly how this knowledge is useful right now. When you hear a politician say a new law is unconstitutional, you now know the real question. Does it exceed the government's powers, or does it cross into protected rights? Those are the only two options. When you read about a Supreme Court decision, you now understand what the justices are actually arguing about, where the line sits between government authority and individual liberty. When someone says, "I have a constitutional right to do that," you can ask yourself whether the Constitution actually limits the government in that specific way, or whether the person is confusing a personal preference with a legal protection. And when you vote, you are not just picking a candidate. You are picking someone who will influence where that line gets drawn for the next generation. Here is what you now know. Constitutional law comes from two questions. What can the government do, and what can it not do? The foundation under both questions is limited government. The first tool is powers, the structure and authorities the Constitution grants. The second tool is rights, the lines it forbids the government from crossing. The three most practically useful ideas from this video are these. 1. The Constitution is the government's job description. Anything not in that description, the government cannot do. 2. Your rights are not gifts from the government. They are fences the government cannot cross. The Constitution is the fence, not the source of what it protects. 3. Powers and rights are not two systems. They are one single boundary between government authority and individual freedom, seen from two directions. Every constitutional argument in history is a fight about where that boundary sits. Constitutional law is not a dusty document in a museum case. It is the operating system running underneath every law, every court decision, every act of government that touches your life. The system follows rules. You now know what the rules are. The next time someone says, "That is unconstitutional," you will not need to nod along and pretend you understand. You will know exactly where the line is. And you will know which side you are standing on. That is constitutional law explained. Simply,